If I could pick one legal myth that quietly convicts more innocent-looking people than almost anything else, it would be the myth that if a police officer doesn't read you, your Miranda rights, whatever you say cannot be used against you, and your case will be tossed out of court. It feels true. It's been repeated on television and in break room wisdom for decades, and it is devastatingly wrong in the ways that actually matter. When you're standing on the side of the road with a body-worn camera pointed at your face, you're about to hear body cam audio from a stop that happened on a Tuesday afternoon just outside a suburban shopping center. The driver believed he was being smart. He believed with the lack of a Miranda warning was his get-out-of-jail-free card. He talked freely, confidently, even helpfully, and every word he said was later used to convict him perfectly legally. I'm going to walk you through exactly what he got wrong, what the law actually says, and what you need to say instead. If you ever find yourself in handcuffs in the back of a patrol car, or just standing on the curb wondering when your rights kick in, the dash-mounted camera shows an officer walking up to a silver sedan. There's a slight fisheye bend to the lens, the kind you see on standard issue Axon body cams. The timestamp reads 14/22/07. The driver's window is already down. The man inside looking more inconvenienced than worried. He thinks this is about a rolling stop. It's not. The officer's voice is calm, almost friendly. Afternoon. You know why I pulled you over? The driver, I'll call him David, answers without a pause. The driver, I'll call him Mark, answers without a pause. Yeah. Look, I probably rolled that stop sign back there. Sorry, I'm just in a hurry. Makes him look cooperative and trustworthy. What Mark doesn't know yet is that the officer isn't here for the stop sign. The real reason is a B-O-O-L-O, a be on the lookout for a silver sedan that left the scene of a hit and run 15 minutes earlier. Mark's car matches the description. He's nervous. I probably rolled it, just turned a traffic stop into something else entirely. And crucially, none of this is a custodial interrogation yet. Miranda hasn't attached. But Darian doesn't know that. Because, like most people, he thinks Miranda applies from the moment an officer starts talking to you. That belief is about to cost him everything. I want you to hear the exchange that follows. The officer asks, "Where are you headed from?" Mark, still eager to appear harmless, says, "Just coming from the mall, hound. I was over at the electronics store returning something." That's a voluntary statement. It's not prompted by handcuffs or the back of a cruiser. It's just conversation. The officer then pivots. And here's the moment the case turns. "We've got a report of a car like yours leaving a crash a little while ago. Did you happen to see anything?" And Darren, suddenly defensive, blurts out the one sentence that sinks him. And Derek, suddenly defensive, blurts out the one sentence that sinks him. "I wasn't anywhere near that intersection. I came straight from the mall. Look, I didn't hit anyone." That's insane. He's now denied involvement in an accident nobody directly accused him of committing. He just gave a false exculpatory statement on body cam with no Miranda warning under no formal arrest. And he still thinks none of it can be used because the officer never read him that little card. Here's the painful legal reality I want you to absorb before we go one step further. Miranda v. Arizona. The 1966 Supreme Court case that gave us those familiar warnings does not say that any statement made without a warning is automatically inadmissible. It says that statements obtained during custodial interrogations are inadmissible in the prosecution's case in chief. If the suspect wasn't first warned of the right to remain silent and the right to an attorney, read that carefully. Custodial interrogation. If you aren't in custody, or if you aren't being interrogated, Miranda is irrelevant, and a traffic stop under the law is generally not custody. The case you want to remember here is Berkemer v. McCarty. 468 U.S. 420, decided in 1984. A sheriff's deputy pulled over a man suspected of drag down, asked him a few questions, and got incriminating answers before any Miranda warning. The Supreme Court held that a routine traffic stop is a temporary detention, not the kind of formal arrest that triggers Miranda. The reasoning was that a traffic stop is public short, far less coercive than a station house interrogation. So any pre-arrest questions an officer asks during a roadside stop are typically not subject to Miranda at all. Mark's casual nay, "I probably rolled that stop sign," and his later denial both happened while he was still sitting in his own car, free to leave in his own mind before any handcuffs were produced. That's not custody. The statements came in at trial without a Miranda fight. But the myth gets people in a second, even more dangerous way, one that goes well beyond traffic stops. Many folks believe in that if they are arrested, but the officer never reads them their rights, then absolutely everything they say afterward is excluded and the charges will be dismissed. That is also false, and the way it plays out on body cam is heartbreaking. Let me give you a second scenario, and then I'll give you the exact phrase that could have saved this person. Imagine a domestic disturbance call. Officers arrive, separate two individuals, and start asking,
"What happened here tonight?"
One person, let's say a woman in her early 30s, is upset, shaken, and absolutely certain that because she hasn't been Mirandized, anything she says right now is off the record. She lets her guard down completely. She tells the officer, "I just want him out. He's been drinking. He pushed me first, but I hit him back harder. I'm not gonna lie. I lost it." She thinks she's just venting. She thinks, without a Miranda warning, that sentence can never appear in court. The officer wasn't interrogating her as a suspect. In that moment, she's a potential victim, a witness. But a few minutes later, the situation shifts. The other person has visible injuries. Now she's facing an aggravated assault charge. The state plays her unsolicited admission at trial. Miranda was never required because she wasn't in custody, and even after she was arrested, that statement was spontaneous and volunteered, not the product of interrogation. The Supreme Court made that clear in Rhode Island v. Innis. Miranda only covers express questioning or its functional equivalent. Blurting something out on your own, even after an arrest, is almost always admissible, warning or no warning. At this point, you might be thinking, so Miranda is basically worthless, unless I'm in handcuffs and an officer is explicitly grilling me. No, it's not worthless. It's powerful, but only when you understand the exact trigger and the exact weapon it gives you. Miranda protection attaches when two conditions are both present. You are in custody, meaning a reasonable person in your position would not feel free to leave. And you are being interrogated, meaning the police are asking questions or engaging in conduct designed to elicit an incriminating response. The moment both conditions converge, if the police haven't read you, the warning, what you say can be suppressed. The problem is that most people talk long before that convergence ever happens, permanently damaging their defense, all while believing a fairy tale about the case getting tossed. Let me show you the single most important distinction I teach my clients. There is a world of difference between a statement made pre-Miranda but pre-custody and a statement made post-custody during actual interrogation. The first bucket is almost always admissible. The second bucket is where your real protection lies. The myth collapses both into one blanket rule, and prosecutors love that myth. They count on you volunteering a mountain of admissible evidence before you're ever formally placed under arrest, and then maybe, but it's too late. The damage is already sitting on the body cam hard drive, time-stamped and irreversible. Now let's get to the actionable part, because I didn't bring you here just to terrify you. I'm going to give you the exact words to say, and they need to become as automatic as buckling your seatbelt. I want you to notice that I'm not giving you, "I do not consent to a search." That's a different tool for a different moment. Right now, we're talking about the right to remain silent and the right to counsel, the twin pillars that Miranda actually protects. When you find yourself in any encounter that's starting to feel like it's moving from casual to accusatory, an officer's tone shifts. You're being separated from others. You're asked to step out of the car. You sense you're the target. You lock onto this script. Say these words calmly, clearly, and directly toward the officer's body cam. Do not whisper them. Do not mumble them while looking at your feet. Say them with conviction. You need them on that recording. I'm going to exercise my right to remain silent. I want to speak to a lawyer before I answer any questions. That's it. That's the full shield. Notice I didn't say, I think I should probably stay quiet, or I'd like a lawyer maybe, or am I supposed to have a lawyer here? Ambiguity kills this protection hound. If you conditionally or uncertainly invoke your rights, many courts will find that you didn't unambiguously assert them, and the questioning can lawfully continue. You need a clear, unequivocal invocation of both silence and counsel. Saying both matters because the right to counsel carries additional weight. Once you unambiguously request a lawyer, all interrogation must cease until counsel is present. Under Edwards v. Arizona 451 U.S. 477, once a suspect invokes the right to counsel, not only must questioning stop, but the police cannot reinitiate interrogation later without a lawyer present unless you yourself reopen the conversation. That's a substantial shield that simply saying, "I'm staying quiet," does not by itself give you in the same rock-solid way. Now, does this mean you should robotically shout this phrase the second an officer says, "hello"? No, and that's another nuance the myth obscures. There's a difference between being cooperative with basic identification and providing information required by law, and voluntarily incriminating yourself. Most states have stop and identify statutes, and if you're lawfully stopped, you generally must provide your name, and if driving, your license, registration, and proof of insurance. Failure to do that is a separate offense, but after that, you're done. If an officer asks, "Where have you been tonight? How much have you had to drink? Why are you in this neighborhood? Do you know anything about a burglary?" You do not have to answer those questions, and you especially don't have to answer them without a lawyer. That's the moment for the phrase, "not before," but the instant you feel the conversation sliding past identification and into investigation. I want to anchor this in one more real doctrine that plays out inside every interrogation room and is almost never discussed in these videos. There's a narrow exception to Miranda called the public safety exception, and it comes from New York v. Quarles, 467 U.S. 649. If there's an immediate threat to public safety, say an officer sees an empty holster and asks where the gun is before Mirandizing, the unwarned answer can be admissible. And that exception gets stretched in subtle ways, all of which underlines this truth: if you wait for Miranda warnings to feel safe, you're operating on a delay that the law does not protect. So let's tie this back to the body cam footage we started with. Later found himself arrested and charged with leaving the scene of an accident with property damage. His attorney tried to suppress that statement. The judge ruled exactly as Berkemer dictates. The initial question heard during a lawful traffic stop, not custody. The denial was voluntary and spontaneous. The statement was admitted, and it contradicted the physical evidence and cell phone location data the prosecution brought in. The jury heard a man confidently denying something that the data proved he did, and that destroyed his credibility on every other issue. He was convicted. It wasn't a dramatic wrongful conviction story. It was an ordinary, preventable, everyday conviction, fed by a myth. If you take nothing else from me today, take this. Miranda is not a magic spell that retroactively erases your words. It's a procedural safeguard that works only when you actively invoke it, at the right moment and in the right words. The myth that it's an automatic case killer makes people talkative in the worst possible window, believing they're protected when they're actually building the state's case for them, frame by frame, on high-definition body cam. Next time, we're going to look at one of the most common questions officers ask after pulling someone over. A question that sounds like small talk, but is actually a carefully layered request for consent. And I'll give you the 3 words that shut that door without escalating the stop. You'll want to have those ready.